Hi, welcome back to Finally Revealed. In this episode, I want to talk about the recent decision, actually was entered August 26, 2019, in the first of many cases concerning the opioid crisis in the United States. This case was brought by the state of Oklahoma, the Attorney General of Oklahoma, against 13 pharmaceutical companies. Many of these are related companies to others, and so there are generally three groups. Two of the groups settled before the case went to trial. Those groups are Teva Pharmaceuticals, which settled for $85 million, and Pharma, which is the manufacturer of OxyContin and other drugs, settled for $270 million. The remaining defendants, generally referred to as Johnson & Johnson and some related companies, went to trial. The trial took several weeks. It started May 28, 2019 and concluded July 15, 2019. And that was tried to a judge. There was no jury. After the trial, the court reviewed all of the records and issued its 41-page opinion. The court found in favor of the Attorney General and the state of Oklahoma and entered a judgment finding that the state of Oklahoma was correct in that these pharmaceutical companies created a public nuisance. The court found that the nuisance must be abated at the cost of the defendants. So that's in general, and then the amount that was ordered under the abatement plan in rough numbers was $572,102,028. From that amount, there would be attorney's fees paid and costs paid back to the state and its outside counsel for bringing the action and all of the work that was required, because the case was filed back in 2017, so it had 2 years or a year and a half of work before then the 6 weeks or 7-week trial. The court found that while the plaintiff set out that the total abatement to fix this problem would take 20 years based upon the damage, they did not provide enough information for the court to quantify the cost beyond 1 year. Oklahoma is like many states. It has a nuisance statute. There's a nuisance statute that basically defines a nuisance, and this one has 4 components. And then when it becomes something that affects a community and neighborhood, the whole state, and multiple people there, but they don't have to have the same amount of damage for each person, but that's what brings it to the level of a public nuisance. So in Oklahoma, the part of the law that they were referring to was the part that says a nuisance consists in unlawfully doing an act or omitting to perform an act which either the act or the omission annoys, injures, or endangers the comfort, repose, health, or safety of others, and in any way renders other people insecure in their life or in their use of property. The court said that the property part doesn't really fit here. However, to satisfy, in case there was any appeal on that ground, the court found that because the defendants disseminated their marketing materials and their sales tactics to Oklahoma doctors, pharmacists, people generally through smartphones, through computers, and their salespeople were driving across the roads in Oklahoma in company cars, that would satisfy the property section, and that was added in by the court so that court said it didn't find that that was special to this situation, and that because of the false, misleading, and deceptive marketing, which the court found the pharmaceuticals engaged in, which created the problem, the nuisance was found to exist. So before they started the case, there were certain facts that the court found either the plaintiff had evidence for that the defendant didn't dispute, or the parties agreed at the onset. Some of the facts that the parties agreed to at the onset are the most disturbing. And those are that Oklahoma had the most prescriptions of fentanyl, these are opiates, are narcotics, and I have a link below to generally tell you what opioids consist of. They said had the most prescriptions of fentanyl per capita than any other state in the United States. In 2017, 4.2% of babies born to Sooner Care, which is the state-funded health care for generally low-income and other families, 4.2% of the babies in just 1 year were born with what they call neonatal abstinence syndrome. Basically, that means these babies were addicts in the womb, and as soon as they were born, they went into opiate, narcotic withdrawal. And anyway, those were agreed to. They also agreed that Oklahoma is suffering a crisis due to opioid drug abuse. From 1994 to prescription opioid sales increased fourfold, 4 times as many in 2006 than is in 1994. From 2011 to 2015, more than 2,100 Oklahomans died of unintended opioid overdoses. In 2015, over 325 million prescriptions for opioids were issued for pills, or actually issued and dispensed in the state of Oklahoma, which for that year, 2015, was enough for every adult in the state of Oklahoma to have 110 pills. Now the defendant's sales representatives were trained in Oklahoma how to spread the marketing message. They conducted deceptive and marketing and sales efforts in the doctor's office, in the hospitals, in restaurants and other venues. They paid speakers to deliver messages and to support programs to promote opioids. They used company cars in Oklahoma to attend the meetings, and they sent messages, as I said, by computers, cell phones, and other mechanisms. So then the court went through what the false, deceptive, and misleading practices were, which that was what the court was asked to find. The state said that this nuisance was created by the pharmaceutical companies promoting opioids in false, deceptive, and misleading ways. And the court found that they sustained that burden, and through these means. They paid pain advocacy groups, and they funded studies which the conclusion was that they needed to prescribe more opiates. They told their salespeople to avoid the addiction, abuse, or diversion conversation. Don't talk about it. They tried to promote that addiction was a scare tactic that created a concept they referred to as opioid phobia. They tried to tell doctors that pain was not being treated sufficiently and no one should have any pain and they should prescribe more of these pills. They suggested that any additional pain that's found scientifically to be caused by taking these drugs, the answer was to give more of these drugs. They said pain was generally undertreated. They said there was an addiction ditch that people talked about, but it wasn't real. They trained the reps to say that there's a lower chance of opioid addiction if the opioids come from a doctor. They targeted doctors, pharmacies, and the general public, and they trained sales reps to key in on high prescribing doctors, those who were more likely to prescribe more. They found that the marketing was very heavy, thousands of pieces, thousands of contacts within a year, overwhelming and pushing on these doctors and pharmacies, and that was through direct means, through speaker programs, and other methods. The court cited that the external FDA warnings to them, the internal warnings and the knowledge by the pharmaceutical companies, and the information they obtained from their consultants was sufficient for them to understand that they were doing this deceptively and that they ignored that. And the court found that the increases in addiction and the increases in the overdose deaths matched the opioid increase in sales, and it was not a coincidence that they were causally linked. One caused the other, and the increase in deaths and the addiction treatment suffered by people and the increased costs to the state also matched with the prescription increases. and therefore the court found that the pharmaceutical companies created this nuisance. The court approved the studies that were presented and reviewed the plan that Oklahoma had already implemented in part and had been receiving success. They didn't wait until the case was over. They went ahead and started approving these different mechanisms to combat the crisis, and the court adopted that plan, and that's where the award of the funds to abate the nuisance came from. The study was based on information received from Johns Hopkins, received from the White House study that came out as ordered by the president. It came out in 2017, from the Oklahoma Commission, and from the Surgeon General, from the Center for Disease Control, and other sources. The goals of the plan are to save lives in the future, to save the current lives by preventing further addictions, and to eliminate the negative impact that the nuisance has had on the state of Oklahoma. And in order to abate the nuisance, the court specifically went through 11 different categories, and it was the comprehensiveness of these categories that resulted in the ultimate number of $572 million. Our first, all eligible people are to get a biopsychosocial assessment and treatment and recovery services. And that's in treatment, out treatment. It's pretty extensive. A second part of the abatement, second part is supplemental services for addiction treatment. And the third item was the third part was public medicine and disposal programs. They want them to enroll in screening, brief and intervention and referral treatment, continuing education, medical record integration, screening for sooner care patients, and universal screening overall. 5 was pain prevention and non-operative pain therapies, cognitive behavior therapies, physical therapies, exercise, and the personnel in order to help with all of this. And part of this is because the opioids block the transmitters for pain, it doesn't address the underlying condition for the pain, and then it creates its own pain, and then the addiction, and goes on and on. So this is to retrain and provide education to address the underlying, and the personnel to do that for 1 year. That is 103. Was overdose prevention education and Naxalone distribution. Naxalone is a drug, and the personnel to deal with this, and the personnel equals all the EMTs, the firefighters, the medics, the ambulance people, and including rural areas. So there's additional costs when rural areas are involved because of distance. The total. Number 7 is medical case management, to evaluation for babies, overseen by the University of Oklahoma Health Science Center, and funding, and to make this condition reportable. Number 9, at a cost, universal substance screening for pregnant women, and training for OBGYN hospitals and practices, and for record keeping, etc. Medical treatment for the newborns above and beyond what normal newborn treatment requires. Number 11, the final one, was pretty all-encompassing. This further investigation, regulatory actions. And this was something to think about. This crisis caused increased burdens on fire, ambulance, and those people responding to overdoses, increased burdens on the hospitals for the addicted babies, increased burdens on the treatment centers for people seeking treatment for addictions. And then this part, chief medical examiner needed staffing due to cases brought in, and law enforcement efforts involved in those cases that have the allocated for abating the nuisance in dealing with the professional boards in the case investigation and dealing with the professionals who became addicted. And those boards included the Oklahoma Veterinary Board, the Oklahoma Board of Osteopaths, the Board of Nursing, the Board of Medical Licensure, which is for all doctors, the Board of Dentistry, and then instruments and equipment for the toxicology lab, new CT scanners, the Attorney General's Office, programs and personnel for dealing with all of the complaints, and the Medicaid Control Division. So those are all of the areas that were impacted by the opioid, or are impacted today by the opioid crisis in Oklahoma. The lawsuit was brought to find that a nuisance existed and for the court to agree upon that, which it did, and then order the abatement. The court retained jurisdiction to oversee the abatement procedure and any other applications for additional costs that there might be going forward. The response by Johnson & Johnson, Janssen, and that group was that they were going to appeal. So we'll follow up on that as it develops, but there are now 200 cases consolidated in the state of Ohio, and those are set to go to trial October 21st, 2019. They are consolidated in it's called In Re National Prescription Opiate Litigation. It is a federal case pending in the Eastern Division of the Northern District of Ohio. If this was helpful to you, please give me a thumbs up. Share this with anyone who you think might be interested. Leave any comments or questions below. And I will link my video on opiates and opioids below. And subscribe to see other videos and come back and see me next time. Thanks for watching.